law says that the decedent's portion has to be distributed the way the decedent wanted it to be distributed. That's not subject to amendment by the survivor. It's not subject to the whim of the trustees.
So, Mr. Boykin, though the question before us is not to determine the merits of the petition, it's only for us to determine whether or not it is in fact a contest in violation of the no contest clause. So it seems to me some of your argument goes beyond that and tells us, you know what, she couldn't even do this in the first place. But for me, that's an argument that needs to go, if you prevail that this is not a contest, that's an issue for the trial court to determine, not for us.
If I may, Your Honor, I think these are matters of law. This is a matter of federal tax law.
I figured you would say that, but in terms of us, the issue was briefed is whether or not this is a contest under either the new law or the...
May I point out, Your Honor, that when the document is not in dispute, and it is not in dispute in this case, the interpretation of that document is a matter of law, and that is to be reviewed de novo by this court. So I don't think it's a factual matter. I mean, the document says what it says.
Well, I'll be curious to hear from opposing counsel whether this document is in dispute or not.
Okay, I'll save the rest of my time for rebuttal.
Thank you, Mr. Boykin.
Thank you.
Good morning. May it please the court. My name is Stephen Snow. I am the attorney for the trustees, Rodney Donkin and Vicki Donkin. And if I might just pick up where that discussion left off, the real question well, first of all, this is a much narrower case than counsel paints it to be. The beneficiaries constantly attempt to rally this court support by referring to all of these allegations of abuse in their proposed petition. And those allegations are really irrelevant. The trustees are not asserting that those allegations of abuse are protected by the no contest clause. They are not holding up the no contest clauses as some sort of impervious shield to claims of abuse, and they're not asserting that the no contest clause ousts any court of any jurisdiction. As the court said in Hearst, the real question in a no contest case is whether asking the question violates the intent of the drafters of the document. And the Court of Appeal found that there were three particular claims in the proposed petition that did violate the distributive claim scheme that was laid out by the trustors in the Donkin Family Trust. Let's first go to the amendment, the Second Amendment. The question there is, did Mary intend to amend the entire trust as opposed to a particular subtrust? There's no question that the language in that Second Amendment, she starts off with a preamble that she refers to the trust, not a particular subtrust. Her language, she refers to the trust estate, which is a term that is very precisely defined in the trust property section of the trust to be all of the property owned by the trustors.
Counsel, did she have the power to do that?
That's really not an issue in this case. The issue in this case is whether she intended to do that. Whether or not she had the power to do that goes to the merits and is not an issue in this case.
But it would also go to the construction of the document. We
Correct.
would assume ordinarily that a person exercises power that they know they don't have.
And that takes me to the second point that the Court of Appeal found to be a violation of the no contest clause. Could she legitimately have believed that she had the power to amend the trust, the entire trust? The answer is yes. Counsel repeatedly insists that the trust had to be divided into separate shares upon the death of the first trustor to die. He doesn't cite any question in any particular language in the trust, and there's a good reason. The trust doesn't say that. And this is not a cookie-cutter trust instrument, and you have to focus very precisely on the language of the trust and what little undisputed extrinsic evidence we have about the trustor's intent to decide this case. This trust says, upon the death of either settlor, not upon the death of the first settlor, upon the death of either settlor, that the trust can be divided into two shares. So, Rodney Donkin dies in August 2002. Mary Donkin has this trust, and she has the advice of counsel in the administration of the trust, and she has a decision to make. There certainly are provisions in this trust that manifest an intent to minimize federal estate taxes. We don't have any extrinsic evidence about how important that those clauses were and how important minimizing federal state taxes were to them. In the McIndoe case, the court said minimizing estate taxes was the primary objective of the trustors. One of the other cases said that we don't have any extrinsic evidence about their intent with respect to minimizing taxes, so we cannot say that was a primary objective. On the other side, the trust also had provisions designed to minimize or avoid litigation among family members after both of the trustors were gone. There was an arbitration clause. There were multiple no contest clauses. And we also have extrinsic evidence of how important minimizing litigation was to the trustors. In 2002, when both trustors were alive, they signed an amendment that changed the trustee structure and removed the beneficiaries from the first successor trustee position and put my clients in as the first successor trustees. But then, when Rodney Donkin died, Mary Donkin had a choice. She could implement the subtrusts, which say, the subtrusts say that they become irrevocable upon their creation. And again, the document says upon the death of either settlors, these subtrusts could be invoked. So she had a choice. Do I implement the subtrusts and put the tax scheme into effect, or do I wait and reserve my power to amend the trust and try to avoid litigation? The only extrinsic evidence that we have on this is undisputable.
If I may just stop you. I guess I don't understand what you're telling us in terms of how the trust instruments to be read. You say that, I'm looking at the language, you say that this phrase, upon the death of either settlor, the trustee shall divide the trust estate into two separate shares. Okay. Hasn't that been satisfied here? Upon the death of either settlor, so Rodney, the husband, dies.
But it does not specify which settlor.
But it says either settlor.
That's correct, but it didn't say on the death. These trusts typically say upon the death of the first settlor to die, and if that's what they intended, that's what they could have said, but it does not say that.
It doesn't say on the death of both trustors either, does it?
Correct. It just says upon the death of either settlor.
But I mean, that's a very strained interpretation, because that sentence occurs in a paragraph that speaks of the survivor's trust and then the decedent's marital share. So upon the death of either settlor obviously means the first one to die in the context of this paragraph. Well, why do you resist that? I would have thought that is not only the common sense, but the only possible interpretation of what that term either settlor means in that paragraph.
Well, I think that I've thought about that question. The structure's in place, so if those trusts are invoked upon the first death, all of those things can function. All of the different subtrusts can function.
What's the other scenario?
You wait until the second death, and you set up a subtrust.
But if there's a second death, then there is no survivor.
Well, you do have a trustor that died first and a trustor that died second. So you do have that relationship, chronological order.
There is no survivor, counsel. There's two subtrusts created: a survivor's trust A and decedent's marital share B and C. There is no survivor in your scenario.
Survivors, in that sense, the term means the second spouse to die. You do have a second spouse to die.
Well, following up on that interpretation, counsel, looking at, and you alluded to this, in the original family trust instrument, there is language that indicated that together Rodney and Mary intended to